Stevenson, for those who don't know me. I started many years ago a homeschool group. It used to be by a different name, but now it's the National Home Education Legal Defense, otherwise known as NHELD. I've been doing this actively since 1989. I want to start out by giving you a little history so you can understand how we got to where we are today. So bear with me. Back in 1989, there was a dispute between a family and their local school district and about how to homeschool. The family said, no, we don't have to register with you. We don't have to do what you want us to do, public school. And the public school said, well, yeah, you do. We're the public school. And that developed into a lengthier situation because the public school then went to the State Department of Education and said, well, don't we have to make these people do what we want them to do? And so the State Department of Education decided at that point to set up a study made up partly of homeschoolers and partly of public school superintendents, et cetera, people in the public school system. This was all directed by an attorney for the State Department of Education. So they met regularly for several months, and then I had heard about it because I, like you, was not an attorney at the time. I was a mom, had little kids, and I heard by word of mouth that these meetings were taking place. So then I inquired. Nobody knew a whole lot about it. So we decided to go up to the meeting and see what it was about. And at that point, the attorney for the Department of Education was leading the panel down a garden path towards coming up with a written document that this attorney would write eventually after the study committee finished its quote-unquote. And the work it was doing was to study something called the NASB guidelines, National Association of State Boards of Education, and they had guidelines at the time for how to regulate homeschooling. And so when we saw that and what was happening, and the skilled person from the State Department of Education leading them down the path toward regulation, some of us got together and said, what do we do about this? And we started to protest. We started to distribute the minutes of the meetings to all the families that we could reach. At that time, there was no internet, and we had to go and do this, physically by copying and distributing in person, et cetera, at libraries where we had meetings to try to disseminate the information. As a result, this slowed down the work of that study committee. So the more noise that we made, the slower that work got, because they wanted to wait until things cooled down before they put out their proposal. This not being the homeschoolers on the panel, but the facilitator, the State Department of Education attorney, who in turn was working with the Commissioner of Education and the head of the State Board of Education. So this was a year-long project, and during that year-long time, we held protests at the State Department of Education, picketing signs. We picketed them. We demanded a hearing before the State Board of Education at a meeting in their building, which we eventually had. We also kind of stalked the Education Commissioner wherever he went in a public forum, and kept asking, what are you going to do? When is that report going to come out? What's it going to look like? Because they stalled. Because they hoped that this would all go away, and then they would come out with their proposal for regulations. We made sure it did not go away, and eventually what happened was the powers that be had called a smaller meeting, one meeting with 3 or 4 people, invited homeschoolers, the loudmouths, to attend this meeting. I was one of them that attended the meeting, and was with the chairman of the State Board of Education, the Commissioner of Education, the attorney for the State Department of Education, and the quote-unquote homeschool liaison for the State Board of Education, and a few of the parents. And what they, instead of what we had expected was this lengthier document regulating homeschooling as a result of this year-long study, what they placed in front of us was basically one or two sheets of paper, and on that paper basically was what we see now as what we know now as the Notice of Intent form. And that was a far better document than what we had expected. And they put it in front of us and said, what do you think about this? So we looked at it and we said, well, that's better than what we thought, but we have a couple of problems here. One is this paper says we must file a Notice of Intent or we will be considered truant. And so we said, we don't like that. You need to get rid of that. And so the commissioner and everybody sitting there said, well, tell you what, we're going to have another meeting like this with some of the superintendents, and we'll get back to you. And so then they had their meeting, and eventually what they decided was, nope, we're not going to get rid of those two parts. We're just going to adopt this at our next meeting. We'll discuss it with the State Board of Education, and the State Board of Education adopted that. But as it quotes, the title of it was Suggested Procedure for Home Instruction. In other words, this was a compromise document at the time so that the warring factions would cease to war, but that they would have something in place to save their face. And intentionally, they left that language in there, although they only adopted it as a suggested procedure. And that way, both sides supposedly would be happy. We would not have it as a compulsory regulation that we must file a Notice of Intent. We would leave it as a policy, but a policy is not a statute. It's not enforceable by law. So that was the way it was left. Now, neither side was totally happy, and the other side, one superintendent in Stevenson, decided he was not satisfied with that, and he went to his legislator and asked his legislator to propose what the NASB guidelines, the basic regulation of homeschooling, to be a law. And so what he proposed was included things like requirements for parents to have a certain education level in order to homeschool. It contained various regulations about the curricula you should teach your children, and on and on. Okay, so this was the bill that was proposed, and it had a public hearing before the Education Committee. Again, this was before the Internet, and we spread out information again and through the homeschooling community, and we showed up in force at that time. At that time, we had 500 people at that public hearing before the Internet. Okay? That was a large amount of people, and we basically killed the bill. So that was the first step. Through the years then, we actually got a couple of bills passed that were reinforcing our rights. One was 10184A, which basically says if you are instructing your child at home, and if the child is a special needs child, if you're instructing that child at home or in a private school, you do not have to receive the services offered by the public school. Because some public schools were trying to compel parents to have the special education that the public school offered, even though they were instructing their children at home. So the legislature stood behind us after having come from, what we had done before by killing the other bill. So now they were behind us a couple of years later and adopted that law and said, nope, parents can reject that if they want to. A couple of years later after that, we had another bill passed because that was Goals 2000 was in vogue, and they were, the public schools were failing, and the legislature was trying to come up with ways to make sure the public schools succeeded. And so they said, well, you know what, I think what we'll do is we'll propose to let the Commissioner of Education waive statutes as an incentive for the public schools to do better. And so we saw that coming and said, oh, no, you're not going to give anybody the authority to waive our right to instruct our children under 10184. So the legislature, again, passed a bill that says, notwithstanding anything else that the commissioner can waive, the commissioner shall not be able to waive the right of parents to instruct their children in accordance with 10-184. Okay? So there were times when the legislature stood solidly behind us to reinforce our rights as parents. Now, you know, people change at the legislature. There's institutional memory for a little while, but then, you know, you get more re-elections and different people in charge. So every so often, there is a problem that crops up. Now, fast forward to 2003, and there was another superintendent who got the bright idea to go to his legislator and say, we need to regulate these homeschoolers. And lo and behold, the bill that came out was pretty much identical to the first bill in 1989-90, okay? And qualifications for parents to instruct, academic curriculum, you know, required, etc. This time, with the internet and only 3 days' notice for the public hearing, we got over 1,000 people at the Capitol for that public hearing and resoundingly defeated that bill. Okay? That was 2003. Again, they remembered that for a while afterwards. But now, 2019. Now, last year, we had an issue with the Office of the Child Advocate. And she was supposedly investigating the problems that we've seen with public school students who were then being given homebound instruction, namely Adam Lanza and the latest Michael Tirado. His mother kept him home from public school. And so in the OCA's report, she started saying, well, yeah, there's problems with the public school and everything, but these homeschoolers, we have to regulate them. So that was probably before last year. But there was an effort by the Office of Child Advocate to, behind the scenes, get support, legislative support, for a proposal to regulate homeschoolers. In last year, we were expecting it. They were preparing for it. They knew now that we have a history of defeating these things when they're proposed head on. And so last year what they did, we were waiting and waiting. We heard a bill might be coming, and it didn't come. But what they did was hold a legislative forum and invited only a certain number of people to speak at this forum to discuss the issue of regulating homeschooling. You know, well, what do we think about that? And this was just really a facade because they wanted to see what would happen probably. And again, we took a hard stand, a hard position, and said, no, we're not tolerating any regulation of homeschooling. We did nothing wrong. These were public school students anyway, and your statistics are all wrong, et cetera, et cetera. And we fought that. And then we had news conferences afterwards demanding to see her statistics and all the information that she based her report on that was faulty. And we made a big stink in the media about it. Consequently, there was no bill that was proposed that year, last year, but there were comments from the OCA, for example, well, we'll just deal with that next year. This is next year, okay? So, again, we're watching the legislature at the beginning, and there's a way you deal with bills in the legislature. There's a procedure, and at the beginning of the year, legislators propose ideas, propose the bill, and then the committee chairman decide okay, well, when we're going to have a public hearing on those bills. And then you have your debate about the public can say whatever they want. And then after that, the committee that it's referred to, in this case, the Education Committee or the Children's Committee, would hold a meeting after the public hearing to debate internally among themselves about whether that bill should come out of committee. If it comes out of committee with a joint favorable vote, then it goes to the floor of the House and Senate for debate. And if they vote on it, then it goes to the governor for signature. Well, what happened this year is, and there's deadlines for each of those steps. So there's a deadline by which the legislators have to propose their bills, a deadline for which the committee sets up a public hearing on the bills, a deadline for the committee meetings on the bills, and a deadline for, when they go out to the floor. Well, we have not seen any bills proposed on homeschooling for regulation. We saw one that had to do with sports, but we haven't heard much about that lately. But we were looking for the bill that the OCA promised. That did not materialize, okay? So what do we see now? Now that it's, almost time for these deadlines to become quick on when they have to have a COVID-free and then a vote on it. So what happens is no proposed bill about homeschooling per se. The governor's bill comes out, and this proposal is one section of a very large bill. And it's slipped in there not for total regulation like we saw last time, but only for, let's just make sure that all homeschoolers have to register with a public school every year. And we will propose some frameworks for the kind of curriculum materials that homeschoolers who are registered then can access, voluntarily for now. So this is kind of sneaked in there. So based on the history that I just explained, it is our understanding, based on what we know, that this was intentionally done this way, not as a full frontal attack, because they knew we would fight hard about that. This was slipped in there, probably hoping that we wouldn't notice it, probably hoping they could get away with it, and probably as a first step. So this is why CHN and NHELB through the years have taken a very hard position on anything having to do with regulation of homeschooling. We value our freedom more than anything. And if you allow them to take your freedom a little bit at a time, eventually you'll have a lot of freedom gone. And it has been my philosophy, NHELB and CHN, many of the board members, if not all votes by the board, to say no, to just say no, to leave the choice up to the parents as to whether or not they want to stand up and whether or not they want to even go along with the notice of intent form as it has been. Now, I want to speak a little bit about that notice of intent form. You understand that was a compromise document, but the really heinous thing, in my opinion, was that they left in there those two items under the heading suggested procedure, which, by the way, nobody puts in anymore. But under the heading suggested procedure, you must file a notice of intent or we can call you truant. Now, that was left in intentionally. Why? Because the State Department of Education has to deal with the public schools all the time, and that would allow the public schools to use those phrases to tell any parent who does not know the history of what I just said, who is not a lawyer and not used to what the difference is between a policy and a statute that you're compelled to comply with, okay? And so the State Board of Education and its lawyers know full well what a statute is, what an administrative regulation is, the only two forms of law that you're required to follow, and what a policy is that you're not required to follow. A guideline, a policy, a suggested procedure. But under the heading suggested procedure, again, you must file it or we will call you truant. Now, that is left in there purely for intimidation purposes. To intimidate and allow public school superintendents, principals, whatever, to use it to intimidate parents to do what they want the parents to do. Now, it is up to each parent to decide whether they want to go along with that or not. I'm not going to tell you what to do. If the government starts to ban something that takes away everybody's freedom, that's where I draw the line. Now, if you know that history and you know that part was left in there to intimidate you, to be intimidated, you should be very upset with that. And what happened through the years was the lawyers at the State Department of Education, knowing full well what a law is and what it's not, they were asked periodically by superintendents, well, do we have to, report them as truant if they, don't do what we say? Because it's confusing, right? They didn't know any more than parents know, some of them, what they should do. Well, the State Department of Education lawyers told them, yes, you can go ahead and tell them to file the notice of intent, and if they don't, you can report the parents to DCF for truancy, okay? And that's why a lot of parents, through the years, not everyone, but certainly some, have been reported to DCF for doing nothing more than saying, no, I don't want to file something that I'm not required to file. That's coercion. That is illegal. There's a statute against coercion, a criminal statute, 53A-192, that says if a government person tries to get you to do something you're not required by law to do, by instilling in you a fear that they will take official action, that's coercion. That's a crime. They can go to jail or be fined for it, okay? Whenever it happens, it comes to my attention that some superintendent is trying to intimidate a parent and doing that, and the parent says, I don't want to do it, I bring up that statute, guess what? They back off because they know full well they are doing something they are not supposed to be doing. It is not a law. Now, that was the result of a compromise. That is why we don't believe in compromises. We have learned our lessons from a compromise, and we do not compromise with our freedom any longer. We stand up against it whenever we have to. And by taking that strong position, we have maintained our freedom in this state, and we don't want to lose it again. So what I'm saying to you is, you new parents who are homeschooling, you moms, young kids, it's time for everyone to understand the history in this state, to understand really what's going on, and to stand up and be counted, because someday your kids are going to need the freedom to teach their kids. So that's why I'm still in the game, and that's why I will never give up on freedom.